It's not independent of the executive.
You've mentioned that the defendant has no right to appear before the tribunal. What are the other rights recognized by all civilized people that these tribunals do not guarantee?
So far, Justice Ginsburg, all that we have before, I think all that's happened is the right to be present. To look to what other rights are guaranteed by Common Article 3, you can look to the additional Protocol 1 of the Geneva Conventions, which specifies rights like appeal rights and the like. But they're the most minimal baseline rights. We're not talking about, Miranda rights or something like that. We're talking about just a set of core ideas that every country in the world is supposed to dispense when they create war crimes trials. And even that minimal standard, the government says they don't want to apply here. And why we think this is enforceable is that Mr. Hamdan is being prosecuted in the name of the laws of war. And he has the right to invoke the Geneva Conventions defensively as a way to constrain the tribunal, to say that it can't.
How do you want us to view his status? Do we accept the government's submission that there's probable cause to believe that he was not in a formal uniform, that he was not a formal combatant, but that he was aiding and abetting or conspiring with Al-Qaeda? Can we accept that there's probable cause for that?
No, Justice Kennedy, for two reasons.
I mean, particularly based on the CSRT hearing.
The CSRT, to my knowledge, never asked any of those questions about uniforms.
You have to give us a beginning point. You have to give us a beginning point.
We would love a beginning point, and the beginning point is an Article 5 hearing, which is required by Army Regulation 190-8 and Article 5 of the Geneva Conventions. The CSRT in no way suffices to do that. It didn't ask those questions about our, uniforms and the like, to my knowledge. Of course, the CSRT isn't in the record, so we don't really know. The government said below that it had, quote, zero effect on this case and didn't introduce it. But be that as it may, suppose that the CSRT did decide that Mr. Hamdan is an enemy combatant. Justice Kennedy, most enemy combatants are prisoners of war. So if anything, all the CSRT did was affirm Mr. Hamdan's separate claim, apart from Common Article 3, to the full protection of the Geneva Conventions.
That would require a determination by a different tribunal that he was not a POW, in default of which he would be treated as a POW and be entitled to a court-martial. Is that the point?
Yes, Justice Souter. If I could reserve the balance of my time.
Yes, you certainly may.